a huge loss for the Trump administration. Trump's Department of Justice said today that it will withdraw the subpoenas it issued to New York Times journalists who reported on security concerns related to the new Qatari-donated Air Force One. Today, legal expert Andrew Weissman said the subpoenas were a glaring abuse of power from the start. Take a listen.
This is either just intentionally lawless or just such a gross screw up that this is one where, if you're a supervisor, you are saying, how could this possibly happen?
The move to drop the subpoenas came after a judge grilled DOJ lawyers for nearly an hour. The Associated Press reported that the judge was, quote, visibly irritated. The AP also reported that the judge specifically noted that he, quote, otherwise would have granted the New York Times request to reject the subpoenas because, quote, subpoenas are the last step, not the first step in an investigation. All of this comes on the heels of a filing from the New York Times itself, arguing that the subpoenas, quote, chilled potential sources from coming forward for fear of being criminally targeted. When the subpoenas were first issued earlier this month, the executive editor of the Times called them an intimidation attempt. Take a listen.
The Trump administration issued subpoenas to 5 of our journalists in what I think is a naked attempt to intimidate the New York Times and to keep us from reporting on matters that we think are essential to national security. We're going to continue to report both about Air Force One and on the circumstances around the government use of prosecutorial power to intimidate the independent news media.
The subpoenas were issued on July 10th with the goal of compelling the reporters to testify. All of this came just before news reports this week of even more subpoenas issuing. This time, the subpoenas were directed to third-party phone service providers, and they sought the phone records of Times journalists and their relatives, all as part of the administration's effort to, quote, unmask the confidential sources who have provided information for the articles about the security capabilities of President Trump's new Air Force One jet. Now, of course, all of those subpoenas will be dropped. Joining me now to discuss all of this is Lisa Rubin, MS Now legal correspondent. She was in the courtroom during today's hearing. Also with us is Maya Wiley, former SDNY civil prosecutor and president and CEO of the Leadership Conference on Civil and Human Rights. Ladies, in a nutshell, what's your reaction to this loss in court, a self-inflicted loss?
Yeah, I was exchanging some signal messages with somebody who was in the courtroom afterwards, and I said, wow, that was brutal. And the person's response was a shellacking. And I think that is the best encapsulation of what happened in court today, because Judge Subramanian gave the U.S. Attorney's Office an opportunity to withdraw the subpoenas at the very outset of the hearing. And nonetheless, they insisted, as you just noted, for an hour that the subpoenas were lawfully issued and continued to have to make admission after admission about a bunch of rookie mistakes that they had made, about reading the federal regulations that pertain to subpoenas to media, about reading the case law wrong. And at the end, after asking for a break, Sean Buckley, who is now the chief counsel to the U.S. attorney, was the deputy U.S. attorney, someone who you would not expect to be in court arguing this motion in the first place, had to come back after seemingly making some calls to Main Justice and saying, you know what, Your Honor, we will unilaterally withdraw the subpoenas. But of course, at that point, the damage had been done because an entire courtroom full of people, from New York Times lawyers to journalists, had seen the embarrassment that he inflicted on the office.
Maya, was this a shellacking, a true varnishing of the...
It was not only a shellacking. I was trying to think of other S words I could say on television and was having a hard time coming up with one. But let me just say this. Good for the New York Times.
Yeah.
You know, the New York Times came in hard to recognize that if we're not going to counter the bald-faced intimidation, and I don't think there's another way to read this, intimidation of independent journalism on a legitimate public interest story about national security, that it literally said, we want to make sure our motion is not under seal. We want to make sure our defense is part of the public record, that really there be a public reckoning. So I'm glad they didn't withdraw it, because I think it's necessary for the public to understand how this has become a department of injustice, something that is a weaponization, where intimidation is the point. And that's persecution, not prosecution, and we need to understand that.
Right, so this is being touted, and I think rightly so, as a victory for the First Amendment. But let's be honest, the First Amendment has taken a beating over the last 18 months of this administration, as this administration has brought media institutions, accountability institutions, to heel. Is this going to make a dent? Does this help turn the tide that the administration was forced to withdraw these subpoenas in the face of what was clearly judicial disagreement with the entire premise?
Well, I think that you can liken this effort to sort of the administration's effort to extract a settlement from Harvard, meaning they never start with the bottom. It's sort of like anti-prosecution 101. They start at the top and use that as an attempt to intimidate everybody else. And so from that perspective, I think it was a big loss. But to your point about the beating that the First Amendment has taken, you know, one of the rules of lawyering is that if you win, you just sit down and shut up. And David O'Neill, the lawyer from Debevoise and Plimpton, who represented the Times, did not do that because he wanted the judge to know, from his perspective and his client's perspective, there are First Amendment issues still. And he said, the efforts that the DOJ had made were replete with bad faith, and that's even clearer now, meaning after this hearing, it has been damaging not only to these reporters' abilities to do their jobs, but to the public's right to be informed. And I think the fact that he wanted to put that on the record speaks to the moment that we're in that you so aptly recognize, Melissa.
Well, so let's talk about this, Maya. The first thing that should be noted here is that typically when the government seeks a subpoena from a media institution, and it does happen fairly frequently, they will make the request of the institution, not of the individual journalist. So the whole idea that this is an intimidation attempt, I think that might be right. Like, to go directly to the journalists, that seems unprecedented.
And to intimidate their families.
Yes.
I mean, this isn't even just the reporters, to your point, when you set up the story. And they didn't disclose initially to the New York Times that they had submitted subpoenas for the records of 2 spouses and a mom, one of whom is does mental health services.
Yeah.
The other is an
there
attorney.
are privacy concerns beyond the scope of the reporting.
But that just I mean, it's a kindness to suggest that that's just being incompetent. That's a kindness.
Although the judge did say that, too, during the hearing. Like, Lisa, it's my understanding based on the AP reporting that the judge criticized the DOJ for what he termed sloppy legal work. And this is not the first time a federal judge has chided this administration and its lawyers. So what do you make of this very public rebuke of the lawyering here?
Well, I think it's not ended because Judge Subramanian had issued an order tonight after the hearing concluded. And one of the things that order says is he wants internal communications from the U.S. Attorney's Office about a non-disclosure attempt. So what they did was, when they went to subpoena the phone service providers, they went to a judge and said, we want the phone service providers to be barred from telling anybody about these subpoenas. They got that order.
And didn't they go to a different judge and not disclose that they had the other?
Well,
anyway.
Yes, they went to a judge and they didn't tell that judge, these are subpoenas about journalists, these are subpoenas about New York Times reporting. And so he really excoriated them for that. And he said, I trust that if you come back before me, we won't have issues that have plagued this from the outset. But then tonight, in seeking those communications, what that suggests to me is he is thinking about sanctioning these people, referring them for disciplinary proceedings or something to that effect.
Okay, so these subpoenas issued from the U.S. Attorney's Office for the Southern District of New York, which was headed until quite recently by Jay Clayton, who is now the president's nominee to be the director of national intelligence. Does this rebuke from the judge factor into those confirmation hearings in any way?
I think it should, because Jay Clayton, when he testified, said specifically that these subpoenas were lawfully issued pursuant to regulation.
The sad thing here, and we're already watching it with Todd Blanche's nomination hearing, is we're watching a party give oversight a pass. and essentially suggesting we'll just believe you if you say what we want to hear, which is not oversight.
Yeah.
These are serious questions, whether it's the Epstein survivors or whether it's the issues of how subpoenas are being issued. And by the way, also to community-based organizations registering black voters, to organizations that are
You want to see people push back.
Yeah, we need to see people push back because it is journalism, but it's also well beyond journalism, which means if we're not seeing our elected officials of any party making sure there's sufficient oversight into what these agencies are doing and what these individuals are saying and actually testing it, then we do not have a functioning system of government that's understanding its role in protecting the public.
Lisa?
I think that today reflects maybe a small moment of victory for the First Amendment, certainly for the New York Times. But do I expect that this will stop this administration from investigating who the alleged leaker was? I absolutely do not. If anything, today was just a series of admissions about sloppy lawyering and mistakes by the U.S. Attorney's Office for the Southern District of New York, a big blemish on the face of Jay Clayton and all those who serve under him, including the very supervisors Andrew Weissman was saying should have known better.